I don't think that the Court of Appeal dealt with it ex parte anyway.
Yeah.
At least he had the chance to be heard. So you have determined this application. In fact, was there an appeal? And you see, you have filed, you have given orders which are basically final. Did you find out to say, okay, we have certified this matter as urgent? There is an appeal pending here. Why don't we fix it for hearing as soon as possible? Because there is somebody who is concerned about this matter.
Thank you for that. But it is not judges who move the appeals. The parties themselves file the appeal. But I just want to refer you to the Supreme Court decision in that dispute, where that matter was actually completely dealt with, and they said there cannot even be an appeal, because the court that handled the matter had no jurisdiction. So no appeal rise. Yes. No, the matter was finally determined by the Supreme Court.
The point I'm making is that we have a disgruntled citizen who was treated badly by the court.
Please, can we read for him the Supreme Court decision?
No.
So that he can understand, no appeal lies. The Supreme Court finalized the matter.
This was process, and process is important.
Yes.
Yes. This is just about process. It's not about the decision.
Yes.
And that's the point I am trying to make. It's just the process. Because if, for example, and it is going to happen, it may happen, somebody is taken to court at 5 o'clock.
Yes.
What is the magistrate? What is the message we are telling the magistrate?
No, the circumstances are completely different. You cannot look at this case, which has had such a magnitude of causing a constitutional crisis to our whole country, to an accused person arriving to court.
Okay.
So we as judges, we look at circumstances the way they are, the way they are situational, the way they are brought.
Okay. Yeah, I will leave that issue there. Now, in the same case, you dealt with Anarita Karimi-Njeru.
The case of?
Yes, Anarita.
The case of?
Anarita Karimi, the famous case of Anarita. And you said that, look, this petition ought to have been dismissed and whatever, because it did not comply with the standards set in Anarita Karimi-Njeru. Nevertheless, we'll continue to we'll go ahead to consider. Am I right? In a similar case, that is Trusted Society of Human Rights. You recall that case where the court robustly held that Anarita was good law. You recall that case? Held that Anarita was good law, that in fact the court should not depart from it. Yes? And in fact, in that case, where the High Court judges said, look, as long as you are setting out something, we are entitled to consider it. But the Court of Appeal said, no, you are bound by it. Then in this particular one, you say, oh, by the way, your pleadings really are not up to that standard, but we will consider it. What is the state of Anarita Karimi-Njeru in terms of our jurisprudence?
In terms of predictability of the judgment and the law and the preparation of pleadings, especially when one is seeking an interpretation of the Constitution, claiming violations of their rights, Anarita Karimi is still good law, because you have to plead with particularity what were the violations, so that you inform the other party who has violated your rights. Usually it's the Attorney General on behalf of the government. And the court is also able to interrogate, these are the particular facts. So, you know, these cases differ according to the circumstances under which they are brought. So sometimes it's very difficult for a judge to give a broad view without the actual facts before the court.
And you know, this is why sometimes we have to be reflective, because in the Trusted Society case, the court had dealt with that Chapter 6 issue, isn't it?
Yes.
And that is the High Court that said certain things, and the Court of Appeal reversed. And from the public point of view, the High Court had made a good decision, and because it led to the removal of somebody from a position. In this one, the public perceives that in fact CCK was doing the wrong thing, but the court excused non-compliance with an ARITA to give a decision which was favorable to the state. So is that something that the court should take into account in terms of how it deals with procedural issues, so that it gives everybody a fair chance, so that if you are saying an ARITA is not good law, apply it across the board, irrespective of whether it is something that favors the state or somebody, or you just say it is bad law and let us all deal with it on the same plane?
Yes.
Yes.
Thank you. Actually, I'm trying to figure out the facts in the Trusted Society case. I'm not quite getting it, but as far as the CCK case is concerned, the point of departure was, first of all, there was no evidence that the DMS was a system that was capable of eavesdropping any communication. Number two, the process of consultation, public participation, had not been completed. It was in the midst of it that Omtata went to court and nipped the whole process in the bud. So the process of public participation had not been completed, and therefore the problem that was there with the CCK of having to deal with the purveyor who had invaded the mobile telecommunication was still a problem there, recognized not only in Kenya, but regionally and internationally. And it's a problem that needed to be dealt with, but properly, with proper consultation to the public, proper agreement on how the system was going to work. So we did not say go install the system. We said go back, consult the public, finish the consultation, then agree with the public how to install it. But now if that judgment was to stay, the problem would have stayed in the market, affecting a cross-section.
So at the end of the day, we agree that an ARITA should be applied in the circumstances of each case?
Yes.
Thank you. Just two more questions, or probably one. In the case of, you remember the case of, this is a very straightforward question. In application of international law in Kenya, you are a trailblazer in that area. Article 2.5 and 2.6. I just want you to tell me, or to tell us, the application of international law vis-a-vis the hierarchy of laws under the Judicial Act. You know, the Judicial Act talks about the Constitution, statutes, those statutes that have been incorporated, common law, and Africa customary law. So you have a statute that has been incorporated, so it's legislation. In that hierarchy, where does general principles of international law fall?
Thank you very much for that question. I believe the principles of international law will come after we have exhausted our constitution, which is very progressive, very encompassing. Sometimes it has even gone ahead of those international provisions. And it is very rare that we have exhausted the theories, the principles that are provided in this constitution. Then we go, of course, to the statutes. Then, of course, we go to the Judicial Act, and then we go to the international law.
Okay. Finally, I've looked at your CV. There used to be a firm called Martha Koome. Did you have any relationship with that firm?
Yes, I used to work there.
You used to work there?
Yeah.
Why is it not disclosed in your CV?
That must have been an oversight because I worked there.
Yes, it is
and
not,
I did a lot of work for
yes.
public while in that firm.
It is not in your CV.
Yeah, you know, my CV is very huge. I think if I were to write everything, then it will be a confusing
So are you
document.
saying those years were not pivotal in your...
They were years I count as practice, 15
Yes.
years of practice.
So it is not there,
Yeah.
and it's important to make a full disclosure.
Yeah.
Thank you.
Thank you. Thank you very much, Judge Majaja. Thank you, Honorable Judge Koome, for those answers. And now I would want to request Commissioner Jero to please ask your questions. The microphone, please.
Okay. Okay, my lady, I want to go straight to your sample writings. Then after that, we'll discuss a bit about your CV. So generally, my questions will revolve around that I can understand your legal philosophy and generally what guides your decision-making process. Now, you know, there's this question of the case of Communications Authority of Kenya versus Okia Umtata. Now, and you'll correct me if I make a mistake. I noted that one of the reasons that informed you allowing the appeal revolved around the interpretation of the word access, which you found that the judge in the High Court gave a narrow interpretation of that word. And then there seemed also to have been the failure by the judge to balance the rights to privacy and as against prevention of abuse of the same right, and also the judge having gone ahead to stop a process of a public participation, which eventually would have meant that this whole process, would have come to a standstill. I don't know that I'm right regarding those aspects.
You are right.
Yeah. So now, so my question then becomes that it seems to me that the issue of public interest that you are taking here into consideration. Now, then again, when I come to this decision of Teachers Service Commission, which to me seems to be groundbreaking because the way we've always known about vicarious liability, there's that Salmon test that we all learned from the university, but the children who had been sexually abused by their teachers, TSC was found effectively to be liable because they seem to have, been unable to exercise their responsibility in a wider sense. Now, those two decisions, I would want to understand what is the critical, what is it that was driving you in arriving at those, at those positions? Generally, because there must be something at the back of your mind that was informing your judicial philosophy.
Yes, before the Constitution of Kenya 2010, we used to struggle with the theories that govern a judge's philosophy of judgments. But with the 2010 Constitution, it is replete with how we should interpret the Constitution. To breathe life to the Constitution, to give value to the value, to enhance the values that are given in the Constitution, to promote and protect the rule of law, to promote and protect the human rights of Kenyans. So the two decisions and public interest connotation, but differently. This is the Communications Authority that has the mandate of managing the communications for the whole country. It has been invaded by illegal mobile operators that have invaded the system. They are not paying the dues. They need to install an equipment, but there are many actors in the market that will be affected. So they start the process of consultation for everybody to understand this DMS is actually supposed to nip the illegal purveyors of mobile communications. And they do consultations, they go on and on, but in the middle of it, before they finalize, they are taken to court. Or Communications Authority is installing something that to eavesdrop on our communication. And therefore now that becomes a case. And then the judge decided, yes, it has breached the privacy rights, therefore it cannot go on. Now what remains on the table is a problem that is unresolved. These illegal purveyors are ranging, they are running wild all over. They cannot, Communications Authority cannot carry out its mandate. So this was really a matter of public interest to define the mandate of a body, because then if the body that is given the mandate to deal with the communication is stopped from doing its work, that affects very many people. It affects also the economy of the country, because then East Africa, there were problems with Kenya and its communications. Internationally, because there is some place where they merge, were also uncomfortable about Kenya. So Kenya was about to be isolated internationally. On the TSC case, it's a matter of protecting our children. When you have taken your child to school, you will not stay to look after your child. So when TSC has employed the teachers, and the teachers are the very ones that violate the children, then we cannot leave TSC scot-free. TSC was saying, look, we didn't commit the violation, we punished the teacher. But we went on to examine what systems has TSC put in place to make sure that children are protected from teachers. Is there a standard operating procedure and in the court? I mean in the classroom, to say, you teacher, you cannot touch a child. And if you touch a child, you lose your job. You know, and also empowering the children that no teacher has any authority, I mean, to touch you or to do anything like this to you. So we saw TSC has some regulations, but they have not even cascaded them to the schools to protect our children. Our children are left to the mercy of the teachers, and we found TSC vicarious.
Okay, that's right. Now, then I've looked at this case of Ethics and Anti-Corruption Commission and Midland Finance and Securities Limited, where basically the respondent, again in the High Court, had sought to stop an audit that was being carried out by PwC. These are the Anglo-recent cases where the government thought that there was no value for money in excess of, I think, 4.9 million euros. That should be about 5.5 billion shillings or thereabouts. Now, but in your decision that you wrote, you are clear that that there was need to allow the process to continue of the audit, because in any event that was not going to determine, did not amount to determining the matter. And if the decision was to be allowed to stay as it was, in the High Court, it would essentially be prejudicial to, so to speak, public interest. Again, I'm not sure, again, if you could explain further what was the reasoning behind your decision, so that I can understand your judicial philosophy.
Yes, my judicial philosophy.
Yeah, my lady, I think you are.
Thank you. My judicial philosophy in this was also informed by justice. As you mentioned, these were the Anglo leasing contracts that were entered for an entity in the UK to come and provide security systems. There are many contracts like that. The contracts were running into billions of money. The contracts were signed, but when the NAC government, Kibaki government, came in the office, I think the Ministry of Finance questioned the validity of these contracts, wanted to evaluate them and see whether there is value for money, and contracted PwC, an audit firm, to audit these contracts. These bodies, Midland Finance, which was supposed to finance the contract, came to court to say you cannot audit these contracts. And the judge of the High Court agreed that these contracts cannot be audited. So when the appeal came before us, we looked at it and said, under the rules, under the Constitution, accountability, value for money, what is wrong in evaluating a project? Even if I have signed a contract that I'm going to build a house here with the contractor, and then I decide, wait a minute, I relied on a QS. Can I have another QS look at it? What is wrong with that? And that was a decision in that matter. We said PwC could look at the contract and give an opinion whether there was value for money.
And finally, when it comes to your sample writings, I notice again this decision of Supernova Properties Limited, where the Mombasa court, actually, they had lost the title. Now, the party was claiming that it is their title, validly issued as far as they were concerned, but you looked at the matter differently and restored the Justice Tower to the public and the litigants generally, taking into account again the issue of the public interest. Now, how do you balance out the proprietary rights of an individual vis-a-vis those of the public when it comes to ownership to property?
Yes, thank you. That was a very difficult decision, and for the sake of the commissioners, this was a dispute of the land where the Mombasa Law Courts, the Justice Tower, is constructed. This land, I think, I don't know whether accidentally or was allocated, was grabbed. And the people who are allocated were claiming it, that it is our private property because we own it, we have the title, we are registered, and therefore we are to examine the proprietary rights like Commissioner Macharia is raising. First of all, before the rights of the judiciary were appropriated, judiciary was not consulted, and judiciary was in possession, rendering services to Kenyans. The arguments by these people who had been allocated the land were very strong. They are saying, look, we have the title. So the judgment is profound in the sense that it says, if a party is in occupation of a land, like judiciary was, and that land has to be appropriated by whoever, that body must be informed, and that body must give its consent. There was no consent by the judiciary. So whoever allocated the land, that was, I think, the registrar of lands or commissioner of lands, whoever it is, to these ROTs, it was wrongly allocated. If they suffered any damages as a result of that allocation, then I think their rights belong to civil matter. Is not, they had no right over that property. Okay. The Justice Tower is there. The Justice Tower is the temple of justice where Kenyans go to seek justice, and that's what we send in the judgment.
Okay, thank you. Now, let me come to your ears in say basically working both as an advocate and as a judge, because sometimes it's what you've done that will speak mainly about who you are. Because in an interview anybody can say anything, but we are more informed by somebody's past. And now I remember you actually when I started practicing, and the Martha Koome I knew is the one who was always out there with the Law Society, fighting, these issues. So there's the second liberation, the issue of political rights and detainees and all that. Even demonstrations. In fact, that's the Martha Koome I remember.
Yes.
Before she became a judge. Now, I would want to understand what was motivating you into all this? Because there are many of us who are in private practice who prefer that this is somebody else's problem. I would want to understand, for you, what exactly is it that was driving you into all this?
Thank you, Commissioner Macharia. I think what was driving me was I was seeking justice. I was representing the public. Those were public interest matters. You remember during the one-party rule, the Kano government was crossing in to take over all the independent institutions. The judiciary was part of the executive. Maendeleo ya Wanawake, the major women's organization, had been appropriated. It was Kano Maendeleo ya Wanawake. The COTU, the workers' movement. The Kano government was trying to take the church, the NCCK, and the Catholic Church, but they were resisting vehemently. The Moi government was also trying to take the Law Society. In fact, at the point at which I became an activist and a campaigner for the constitutional review, independence of the judiciary, is when there was an attempt to influence who becomes the chair of LSK. So I was driven by public interest, the search for an independent judiciary, because I was a young lawyer and I could see unless we have an independent judiciary, then I have no future as a lawyer, even if I have my own practice. So that's why I joined with other lawyers, and we started the campaign of review the Constitution, review the laws, repeal Section 2A. Section 2A was repealed, but the institutions of one party still remained. We campaigned, we had the 1997 IPPG, partial reforms that even introduced, some little affirmative action in nominated seats, so that nominated seats and to take into account gender parity. It never happened. I remember myself on behalf of FINDA with Jean Kamau suing Moi, the president then, for not complying with constitutional amendment that required gender parity. But of course the case was struck out because it was said we could not sue the president who was in office. He was immune from civil and criminal liability. So this is work we did at the Law Society. FINDA also realizing my clients whom I was representing, because the firm where I worked when I was first admitted as an advocate, I was a junior associate, so the partners would not take cases for women. They were time-consuming. The women had no money to pay, and they said these women they require a lot of emotional support. They cannot render them a shoulder to lean on. So those cases were thrown to me. And as I came to court, I saw how difficult it was to convince judges using 1882 Married Women's Property Act to say this woman who has been married for 20 years or more, or even 10, has been thrown out of her matrimonial home. She needs a share of the matrimonial home. She needs maintenance, children, all that. I saw how difficult it was. So that's why I joined FINDA, so that we could solidify our voices and seek law reform that took care of families. Because families are important. Families are the foundation of the society. So I've always been driven by the quest for justice. And whatever work I do is defined by the situation in which I am in. Whatever God puts in my hand, I try to do better. I try to be innovative. I try to achieve the very best from the circumstances. So when I was at FINDA, I was a firebrand because the work required me to be a firebrand.
Yeah, which is where I'm coming to actually FINDA, because that's the other Martha Koome that I knew of before the judge. Why gender equality and children? Because again, the Martha Koome I knew in private practice was so firebrand, apart from, of course, the political issues on women's rights and the children. I would want to understand what exactly, because this seems to have been your life, even up to date, I'm not faulting. I'm actually.
Yes.
It's something I like.
Yes.
There's nothing negative about it, and it's something I'm also passionate about. That's why. But I need to understand why.
Yes, I think I'm an all-round lawyer. Even when I was practicing, I was a conveyancer to boot. By the way, I was representing some corporate clients who were actually able to pay my bills. I practiced in the Mirimani Commercial Court. I practiced land law. I was an all-rounder. But what pricked my conscience was the violation of women's rights and children's rights. And this was a threat to the family. And this was a threat to the country. You cannot have a country where families are acting. Because if you're okay at home, everything is working at home, even when you go to school, you will excel. Even when you go to do business, you will excel. But if there is skirmishes at home, there's no peace at home, there's no harmony at home, then you cannot thrive anywhere. I perceived women's rights and children's rights to be central to the family because they anchor the family. And I realized there is a big gap. For women, there were no laws completely. You know the raft of laws that have been enacted from the matrimonial properties, protection against domestic violence, matrimonial acts, all those acts that have come were not there. We were relying on those English-owned registrations, and we used them, argued cases all the way to the Court of Appeal, and they became precedents to inform the future review of the laws. And children as well. Children's laws were scattered in 17 statutes before we came up with the Children Act. And children have vulnerable because they are young. They don't speak for themselves. Somebody needs to speak for themselves, to speak for them. Today, we have this Constitution 2010, which is very progressive, but the Children Act has not even been reviewed and realigned with the Constitution 2010, but I'm proud to say the committee that was put together by the NCAJ, which is a body of this JSC, has worked on a draft children's bill, which is currently at the floor of Parliament for consideration.
Okay.
Yes.
You are involved in Echaria versus Echaria?
Yes, I was. Echaria was, Priscilla Echaria was my client.
Yes.
Yes.
Now,
but it went all the way to the Court of Appeal.
Yes, I recall. And that's
Yes.
why I'm saying I remember that again when we're in a private practice.
Yes.
Now, what is your take home in that matter? Because, of course, it's one of the major cases that have been used again and again when it comes to issue of a matrimonial property.
Yes, I think the Constitution and the Matrimonial Properties Act now have settled the issue completely. So we do not have to navigate the 1882 Married Women's Property Act, English registration, and precedents from outside the country. We are good with the law as it is.
Yeah.
It defines what is matrimonial property, what is direct and indirect contribution, because the ratio decidenda in Echaria case was a contribution, especially indirect contribution.
Yeah.
When a woman is married, say she is a housewife, but she is looking after children, she is doing household work at home, looking after the husband, supporting the husband and the children. When it comes to the division of the matrimonial property, what value can you give to those indirect contributions? So I think the law now is clear. So we won't go into the merits because those are ripe disputes.
Yeah.
Yes.
Which brings me now to the question. Of course, if you become our Chief Justice, you are Chief Justice of all. But this issue of gender equality and children's rights, we seem to keep throwing it to the back burner. High-sounding statements, political statements and all that, but we don't seem to get it right. Now I'm wondering, as the leader of, the one to guide the jurisprudence development at the Supreme Court, the apex court, and generally also cascading it, within the entire judiciary, what steps would you take as our Chief Justice to ensure that, we're able to also use the law to resolve this issue? And I say this because we must accept that countries that have done very well when it comes to gender equality, they are doing very well, but we seem here to keep, struggling and fighting over it as if it's a bad thing. It's like we have to fight over it. And when I say gender equality, both ways, because again, we also don't want it to now move against men. But what would you do, finally, if you're given that opportunity to make sure that you're able to run with this agenda and we sort it out?
Thank you. I think the law is established, and that's the first step. But as we know, laws are always not the panacea of all the problems that we have. We have a big problem in this country of creating awareness, informing people that this is the law. For instance, I wouldn't understand why somebody in 2021 would tell a daughter of a deceased person that she is not entitled to inherit the estate of the father. It is there in the Constitution, it's there in the law of succession. So we have our own cultural beliefs, cultural practices about what we perceive a woman to be, but this is all a matter of education. We will get there. The cream will come on top because we will get there.
Yeah.
It's a matter of campaigns, and I see we have a good entry point to do that through the Court Users Committee, which is a multi-institutional stakeholder body, involves everybody. For instance, when I was in Kitale, we had so many problems of child abuse. And the court users decided we cannot stay downstream waiting for children to be defiled and cases to come to court for the court to sentence these people to 20 years. Because when you go to jail, you find the majority of the convicts are sexual offenses. So that court user committee of Kitale Law Courts decided we are going to do a public education campaign. I was the chair of that court user committee, but I never went to any of those barasas. But they went to the chief's barasas, they went to the local radio to explain to people, here is the Sexual Offences Act. This is what it provides. It's a very serious act. If you listen to those radios, they were using very good examples. They were saying, if you go and violate somebody's daughter, you will suffer the consequences of the man who went to milk an elephant. So you know, when you use those terminologies, you now reach out to the people for them to understand what it is, what does it mean to milk an elephant. You will actually die, you won't leave the place. So that is what it means to violate a girl, to violate a child.
But my lady, my only concern is that being a patriarchal society,
yes,
which you also mentioned, you find that it's your judges who, when they're interpreting the law,
yes,
will also be informed by the same prejudices. In interpreting the law, they come up with the same prejudices that, you know, their customary and, you know, their background, their history. So, which is why I'm trying to understand what would you now be able to do, even so that even when the interpretation of the law is being done, is done in a way that is also able to promote the same principles of gender equality and
yes,
protection of the vulnerable, particularly the children.
Yes, I think when I'm CJ, the colloquiums, we will spend some time to get judicial officers understand what is required of us by the Constitution when you are making a decision. Your personal beliefs, your cultural beliefs, your religious beliefs, your own attitudes, you have to put them completely in the back burner. You just have to embrace the Constitution. Give interpretation of the values that are provided for in the Constitution. Give the meaning of the law as it is. It doesn't matter who you are. And then the rest, those who have received that judgment will grapple with it to see how to implement it.
Okay.
Then that becomes another stage, yeah, where we still go back to the court user committee to explain to people, you know, that if it's a judgment of the court, you have to appeal if you're not happy with it. If you appeal, you lose, then you have to live with it.
Yeah. Now, I want to spend my last few minutes on matters now that relate directly to administration issues, administration of justice within the courts, because it affects lawyers and, of course, by extension, the people that they represent. Because lawyers generally don't represent themselves, they are representing members of the public. Now, you mentioned about Kitale, where you went and the court was not functioning for about a year. And then you went there, and of course, you know, you resolved the issue, which is a good thing. And this has not been uncommon. I remember there was a time when the same problem was there in Eldoret. Lawyers were not being heard, they were complaining, and the courts were not functioning. There was a time it was happening also in Kakamega. So different parts. Now, how does a Chief Justice responsible for managing the institution allow a problem to simmer for a year, which is not just affecting the lawyers, but also affecting members of the public who need to access justice? How does that happen? What exactly is the reason that it's allowed to escalate to that level where, you know, the system of justice has come to a standstill for a year? And for you, what is it that you do to ensure that you don't have those kind of situations?
Yes, that is a very far-reaching question on the administration of justice and the relationship between the stakeholders, the bar, and the bench. I think modern management of the courts that are now well run by the principal judge for the High Court and for the courts of equal status, the end of the station. You know, I see now a better structure than prior to the reforms in the judiciary that would respond, I think, faster when there is a stalemate like it was in Kitale. Knowing how proactive even our acting Chief Justice has been, a problem like this would not even last a week before she has addressed it. My lady has been quite at hand to deal with it. This is a problem that should not be around to pester. Immediately it is brought to my attention. If I am Chief Justice, I would address it and find a lasting solution to it. The lawyers there were unhappy with the judge who was there. So that is a matter really to sort out quickly. It didn't have to wait for me to be sent there a year down the line. I could have been sent earlier. So that's another, a style of management. When you have a complaints office, you don't expand the complaints office. You deal with the complaints as they come, Then you don't have to be overwhelmed, and you don't have to clog the system with the complaints. Deal with them as they come.
Yeah, I agree. At least currently things are working better.
Yeah.
Now, there was an issue that was raised by Commissioner Warsame, where during your time as judges you are few and you'd be able, the output was much, much bigger, which is true. Because even I have now practiced for that years. And when I compare when the judges were fewer, things seem to be moving than now that we have many judges. Now, and he addressed the issue of, say, for instance, of a commercial division. And I'm just using that as an example. Now, would you think that sometimes when it comes to the deploying of resources, putting judges where they are best utilized, where you pick a judge who may not be very good, who may be very good in family law matters, on criminal, but not good in civil, in commercial matters, not being able to optimally use the resources that we have. Now, would you think that has contributed to the problem? And if it has, what steps did you take when it comes now to deploying of your resources so that you're able to be optimal in terms of even making sure that things are able to move a little bit faster?
Yes. Litigation has also increased, Honorable Commissioner, as opposed to pre-2020 because of the new rights that have been introduced in the Constitution. But there is something I've not been able to understand, whether also the land disputes have increased, because we used to deal with them together. And they were not that dominant. They didn't, to me, look like they are the ones bothering me. In fact, what was bothering me was the criminal cases, because I had to do the murder cases and all the appeals, the criminal appeals coming from all the magistrates' courts in Nakuru. But when civil matters were concerned, so there is something we need to look into deeply, and this docket allocation and the methods we are using for work. When we evaluated ourselves as the Court of Appeal, we also found that we write very long judgments, very long rulings. Like a ruling on a stay, seeking a stay of execution, the principles are already established. All you need to do is show this appeal is arguable. And unless stay is given, it will be rendered nugatory. Do I need to write 5 pages on that? So we have come up with a process, a procedure of writing very short rulings, because there's nothing new. There are no new grounds we are breaking. And out of 100 matters that our judge is doing, probably one may be a groundbreaking, where you write a long judgment. The rest are mundane things. Mundane things. So those are things we need to look at and see whether we are spending more time writing very long judgments which are not necessary. Whether everybody has their own docket or the cases are just moving on a conveyor belt, so that there is ownership and individual accountability. Kenyans want to know the value for money. The employers, we have all these privileges. At the end of the day, they want to know, and even me, I want to know, the Chief Justice wants to know, what have I done for today? Am I entitled to this salary I earn? Am I entitled to this car that I drive? Individual accountability. And that will go a long way for people to understand accountability.
Yeah, but also, my lady, I agree with everything you've said. Wouldn't it also be better, because we know judges who are very good in commercial matters, then they are taken to criminal division, or criminal division, they are very good at that, they are taken to commercial law division. Wouldn't it be better also to put somebody where their skills will be better utilized, instead of putting them somewhere where they're going to struggle?
I agree with that entirely, because like a judge who knows, family law and likes it, has no issues, you better leave them in the family law, they'll be faster. Somebody who is good at commercial law, it is called matching talents, and I think it's the modern way of management. You match people's talents and put them where their output will be greatest.
Yeah, which brings me now to the next issue of transfers.
Yes.
And, this is something that there's a lot of grumbling among the judicial officers, the judges. Nobody ever wants to talk about it, but it's a real issue. Now, and there's a policy regarding it. Now, if you become our Chief Justice, what steps will you take to make sure that you resolve this issue? Because I know you know what I'm talking about, this issue over the transfer. And I can see you've mentioned somewhere that you're instrumental in coming up with the transfer policy in the Court of Appeal.
Yes.
You helped in developing that. Now, how do you ensure that you're able to resolve this issue? Because the reality is there are some judges who are permanent fixtures, or some magistrates in certain stations which are considered good stations.
Yeah.
There are others who are always being thrown into what are deemed to be outlying districts. I mean, how do you ensure that you manage it in a fair manner, sticking to the policy and, so to speak, these complaints are dealt with?
Yeah, thank you. I think my administration will be governed on the basis of fairness, and we follow the policy. I was the chair of the committee that came up with the Court of Appeal policy on transfers. And if there is a court where there is no problem about transfer, is the Court of Appeal. We all know that everybody wants to serve in Nairobi. Because when you attain this seniority, you have established your family in Nairobi. Nairobi has all the facilities, hospitals, everything. So everybody will want to stay in Nairobi. But we said, look, we are all court judges of the Court of Appeal. None is lesser than the other one. So we'll do rotation. You will go serve in Nyeri, in Kisumu, and Mombasa for 2 years. Those who are serving outside will come to Nairobi. Those who are in Nairobi will go outside. And it has worked very well. There are no squabbling. So for the others, judicial staff, judicial officers and judges, the policy must be followed. So that we bring predictability, we bring equality in the way we serve, that nobody is being favored, everybody is being treated equally.
Yeah, so my last two questions, which I'll combine together because of time.
Yes.
I would want to deal with the issue of ICT.
Yes.
Because, yes, there has been steps made, but we all agree that what we have now is auto manual. It's not really a proper automation. Accessing the system, lawyers cannot even be able to print receipts. There are a lot of challenges, and we are fighting over it. But we can't go back to manual. We want to keep moving. I need you to explain what steps you would take if you become our next Chief Justice to at least start moving towards resolving this issue so that we are completely automated. It has become a tired story, where everybody talks about automation. We are doing it, but in reality, there are serious challenges which are also affecting our access to justice. I would need you to deal with that. Then secondly, which is my final issue, ensuring fairness amongst all in the staff, I mean everybody within the judiciary, and I'm talking specifically about, because these are things that also they're grumbling about, say for instance, a chief justice who comes, they start favoring their own, community-wise. We are also a country that is that has to keep grappling with the issue of tribalism. I don't know, how do you deal with that, so that if you are the chief justice, you are chief justice of all, and even the staff know that Martha Koome is our leader, and regardless of where I come from, it doesn't matter. I will need you to address those two issues.
Okay. Yes, the issue of ICT, I agree with you, is very important. I've been in this judiciary for 18 years now. And since I joined, we were to embrace technology so that ICT becomes an enabler, because it plays a very key role in especially record keeping. One thing that we should never lose is the fact that COVID-19 brought with it digitization. Because this program has been on. I go to Nyeri, I find cables are arranged all over. There are speakerphones on the table, but they don't speak. They don't record anything. A contractor was given money to lay the cabling, to put the speakers. They never worked. He took the money and he went. So that was a brightened project. When you start another one, we had a room here transmitting live proceedings, connecting with the courts. It also died. So now that COVID came and forced us to put in this, you are calling out or manual digitization, and I really thank the Honorable Chief Justice Maraga. He worked very hard to get that system in place, that system moving. We should never lose it at all. We should continue handing, seeing where it is not working, and build it up, and get the birds that work, get contractors who are credible, because I think the problem we have been having with ICT is not getting credible procurement of the right equipment that works. And I believe we can be able to get that. The other problem I've seen now that I've been working with it, there is the fear. We have to move with the staff. There are people who think that when technology takes over, they will lose their jobs. But the Court of Appeal has been able to assure everybody that we are retraining them. We are retraining them now to record the proceedings. Because even with a rudimentary mobile phone, you can be able to record. And when we started, Commissioner Masaria, you'll be surprised, it was very rudimentary. COVID came, we were told work from home. Urgent matters have been filed. So the registrar worked very hard. The registrar of the Court of Appeal, Mr. Selem, never rested for like 3 months. He was coming to court every day to see how the court can keep going. You would send us all the urgent applications or matters that have been filed with our emails, individual emails. When we started, we were actually communicating on our WhatsApp. We get the 3 of us, the bench that has been constituted. We discuss the matter on WhatsApp, and we agree, we do the ruling, and the ruling is issued. We moved to Zoom. We worked with the Zoom. Now we are on GoToMeetings. GoToMeetings is able to record even our proceedings, because when I'm Chief Justice, one thing that we should stop is recording proceedings with our hand, because we have to protect the credibility of our data, and we are courts of record. These records, which will be taken maybe all the way from the magistrate's court, sometimes all the way to the Supreme Court, is what the judicial officer or the judge recorded with their hand. And sometimes you get tired, you can fall asleep, you can gibberish, some things which nobody can decipher, proceedings which really don't make sense. So we must own on to this with our teeth, if it means owning it with our teeth, until we digitize the judiciary. And it is possible. Even the problems we are having, those are teething problems that we should constantly address. But we should never go manual.
Yeah, I agree. The last issue, being a leader of all, tribalism.
Oh, yes. This is a critical question because of the perceptions. But I believe JSE has put in policies on hiring that take into account diversity, take into account fairness, merit consideration. I'm a human rights defender, Mr. Macharia, myself. I am a very equitable person. I am never driven by things that are outside the Constitution. I always see the bigger picture. So I wouldn't use my office to give favor to my relative or my tribe's person. These jobs belong to Kenyans, and we must actually comply always with the requirements of our Constitution and the policies that we have put in place.
Okay, thank you very much. I wish you well.
Thank you.
Thank you very much, Commissioner Jero. I will now request the Honorable Attorney General to ask his questions. Commissioner.
Thank you, Honorable Chair. Milady, good afternoon.
Good afternoon.
I will be brief because many of the questions I would have asked have already been addressed by my colleagues. But having described yourself as a visionary and transformative leader, could you summarize for us what you would consider to be your vision and transformative agenda for the judiciary over, say, the next 5 years?
Yes, thank you very much. When I was preparing for this interview, I read the JTF, I read the SJT, I read the Sonja reports, and I really commend the tremendous work that has been done in transforming the judiciary. First of all, looking at this constitution, it requires a reform-oriented Chief Justice who will be able to carry on that transformative agenda, that foundation that was laid by Chief Justice Willy Mutunga and has been trajected to the building blocks that Chief Justice Maraga has put in place. So my transformative agenda is to carry on with those transformation to fruition because we know how delicate the judiciary is right now. We are at a trajectory where we can lose everything and slide back to where we were unless the reform agenda is pushed to another level. So I will begin with the evaluation of what has already been done. But one thing that cuts across and which still would remain the theme of my visionary transformative agenda would be to ensure that we have an independent judiciary that is expeditious in the disposal of cases and that is sensitive to the Kenyans whom we serve, that is that centers the delivery of justice to the Kenyans. So the same objectives would remain, that is access to justice. First of all, ask myself, is justice accessible? We are talking of mediation as a forum, alternative justice system. we are talking about working with the counties and other stakeholders and identifying whether we need to build more courts, because we don't just build a court. As a judiciary, you have to engage the stakeholders and see whether there is need. When I looked at those two strategic plans, the distance, the average distance for a Kenyan to access a court is 175 kilometers. I would work hard to reduce it to maybe 100 kilometers in the next 5 years, and this is possible working with other stakeholders. Then, of course, ensuring also the increment of the human resource capital register. I think I mentioned that it is low, it is 56%. Perhaps in the next 5 years, bring it to 75% of the judiciary so that we can deliver justice. There are many projects that are incomplete infrastructural needs. I think even where we are seated, we all appreciate that the Supreme Court, the Court of Appeal, should be not what it is. I remember I think 2 years ago, His Excellency the President came here during the State of Nation address, and he was embarrassed to see where the judges sit in this building. I remember him offering even the KICC as a premises for us to use. But consulting stakeholders, this commission, I think we have a very nice area here where we can build a very nice, vibrant, extend the facility here. So I've identified also infrastructure, and I've also identified resources, resource mobilization, how to fast track the judiciary fund. I am a very good fundraiser. I was the chair of FINDA those days in the late 90s, 2002. Our budget, our yearly budget was 150 million. It was a lot of money then. And it was a basket funding. We had no problems to get donors put money there. So this one, when you show them the deliverables, development partners, and you tell them this is our objective, to make justice accessible, to protect the rule of law, to coordinate the entire justice sector, and Kenya will be safe and free for all to live and realize their potential, and get a strong office that can also write grants, So we can get money in the consolidated fund, we can work with the counties to build the courts, and then ICT, of course, is central to all this. Get good procurement systems in place, and an audit for money for value. Especially accountability is very critical. If you cannot show value for money, then that's why you get the push and pull. Basically, my vision would be to continue with the transformation that is already on the ground and propel it to another level and strengthen the judiciary, so that when I'm leaving, my legacy is that there goes a judge who was really a defender of justice, who was really a builder of an independent institution that can stand all the time. Yes, thank you.
Thank you, my lady. And what would you consider to be the greatest threat to achieving what you have just said?
There are many threats. First of all, this collaboration, this linkage with other arms of the government needs to be strengthened, need to be understood. The independence of the judiciary needs to be understood clearly, that it is anchored in the Constitution. Nobody can touch it. It is untouchable. It's a no-go zone. But we have very many areas of interdependence where we have to work together to serve Kenyans. So that is one threat. The next threat, of course, is funding. I'm aware of budgetary constraints in the entire government because they have also been made worse by the COVID-19, which has threatened livelihoods. People have lost jobs. KRA is not able to collect taxes, but we are so privileged that we still get a salary serving Kenyans. So this is why I'm saying I will use my skill, my networks with partners. Like, for instance, when I served at the NCAJ, the Special Task Force, we never got any money from the judiciary. We drew our work plan. We identified the activities. We called UNICEF and IDLO and told them there were already partners working with the judiciary, and told them these are the activities we need to do to return the report that is required of us and the work that is required of us in the 16 TORs. And UNICEF said anything touching on the protection of children we will do. The U.S. Embassy, Department of Justice also came in and said we'll do the service weeks, go around this country and finish all the pending cases for children because they are impinging on the well-being of the child. They are touching on their human rights. So we went around and did service weeks. And
so you fundraised?
We
yes.
fundraised and did the work.
Thank you. Let's move on to the aspect of collegiality, which was addressed by my lady, the Honorable, the Acting Chief Justice. This is the scenario, my lady. You're in the Supreme Court, and the Supreme Court, as you know, has a representative in this commission. And two of the members of that court indicate serious desire to represent the court. And that splits the Supreme Court in at least two very distinct, if not three or more. You are the Chief Justice. What would you do?
Well, I also come from a collegial court, the Court of Appeal. We are a collegial court, always also the chair of the panel, now leading the division. I belong to the leadership committee of that court. And I'll share the experiences of how it works, especially in sharing leadership positions.
But as you do that, could you address the question that has been put to your ladyship?
Yes, about collegiality. Collegiality, which I described as teamwork, works through consultation, discussions, and bringing the matter to understanding. The matter that is causing the disquiet, the matter that is splitting people, bringing it to an understanding. And in a court of 7, this is very easy to achieve. All we need to do is have a couple of ranches, because for the Court of Appeal we eat together, and when food helps people talk nicely. So we will have a couple of retreats eating to understand what is the problem. The problem is a member to represent the court to the JSC. We are only 7. Just see one has already served, has already represented, so that one is out, leaving the other 6. I think 2 have served, so you are only leaving 4. Just discuss the formula that can bring fairness. And you can even say it will be rotational. This one, when they finish, next one will be this, the next senior most. Because these positions are not running away. And we should never lose sight. Why are we Supreme Court? What is the mandate of the Supreme Court? What is the objective of the Supreme Court? That is the North Star. That is the guiding one. So this other disagreement, we talk, even if we have to go late in the night, until we agree. And we can agree because those are very few people to bring together. And I'm very skilled in negotiations and with humility in getting people to see the bigger picture and letting people see why we should sometimes cede even what we think should be ours.
Thank you very much, Milady. Now, the Chief Justice offers jurisprudential leadership in the Supreme Court. How would he balance that responsibility or that role with the individual and collective independence of the judges and the court?
Yes, because the Chief Justice is a judge. Beyond the leadership role he plays, when he wears the hat of a judge of the Supreme Court, he is one among equals. He is entitled to his own opinion, just like all the other 6 are entitled to their own opinion. So he can express his own individual view or opinion on the matter. And then if he is the presiding judge, he will listen to the views or the opinion of the others if they are sitting as a full court of 7. Then in those discussions, it emerges who is with him in his thinking and who is against. Let's say, who is for the appeal being around or the petition being around, and who is for the petition being dismissed. So that is how in a collegial court you discuss matters, and it has happened even in other countries, like in the US. If you read the story of Ruth Bader Ginsburg, RBG, one of the leading jurists in the US, she passed away recently. She gave the example of the Supreme Court of US, where there were very divergent views on a matter, and there they can really have a standoff because some people are aligned to the conservatives, others are aligned to the Democrats, depending on who has appointed you. And Ruth was very progressive, a Democrat, a human rights defender, really expressing herself in a way that was developing the law, including even proposing that US, which is a very closed community in terms of appreciating international law, we can use some of the human rights law and decisions, even from Africa, to inform and develop the law in the US on certain issues where we have made more progress. But she was able to work with judges who had very diverse opinion and backgrounds and views, because once you discuss in a collegial setting, you actually realize there is more that brings you together than what divides you. You know, there could be the very mandate, objective of the Supreme, or what makes the Supreme Court, that is the apex court, is the image of the judiciary, is the one giving us judgments that are precedent setting, is so overarching, is so overwhelming that I don't have really to dwell on the little matters until we divide the court and bring it out there as a court that is disjointed. So these are matters of discussions with top minds, people with opinions, but I believe there can always be a solution so that the Supreme Court projects an image of a court that is generating jurisprudence that is well-reasoned, that is authoritative, that is used as precedents.
Thank you, my lady. A couple of more questions. Where do you see the aspect of judicial activism in the development, future development of the Supreme Court?
I think the Constitution of Kenya 2010 has quelled any anxiety that we would have any gaps in the law in terms of interpreting the Constitution. The values there the rights that are enshrined there, including socio-economic rights, rights for the marginalized, the rights for children, human rights, participation, consultation. It is so encompassing, the Honorable Attorney General, such that to go outside of this is really a very one-off situation that leads you to seek persuasive authorities from other countries or other sources. And then we have the augmentation of the international human rights law that have been accepted by our Constitution to use if there is any need to fill in the gap.
All right. Finally, is there corruption in the judiciary, milady?
My goodness, I was hoping I would not be asked that question. I'll look at corruption from a two-pronged approach. Judiciary deals with cases of corruption. Corruption is endemic in Kenya. It has permeated our government, our society, the way we do things. There are very many cases of corruption that are pending in our courts. And that's part of the perception we have as a judiciary, that we are not fighting corruption the way it should be. And moving forward, when I'm CJ, we shouldn't engage in game brain that, oh, is the prosecutor who didn't prosecute the case properly, didn't bring evidence, is the police who did not investigate the matter properly, is the lawyer for the accused person who didn't do what. And this is why NCAJ was formed, so that you look at the administration of justice and see where the challenges are. And the challenge that I will see is the fight against corruption. And when minds come together, there is always a solution. And the example I will use is determining election dispute cases. They are determined timelessly. Within 6 months, we complete them. Because all the actors come together, decide this the period of election. Courts, we train the people who will deal with the petitions. We put in a committee that monitors on a daily basis what is happening. If there is a problem, and my own Judge Majanja, I think, is one of our leading experts in those committees in monitoring the progression of election disputes. So we have expertise which we can use to help us come up with a system of case management of corruption cases so that they are finalized within a reasonable time. The same committee like the election petitions can be put regarding corruption matters to fast track all of them and see if there is one which is having complications or delays, what is the problem, address the problem and let it move. That way, those cases that are pending there will be finalized within a reasonable time. Money will be released to the economy so that it can do what it is supposed to do. Then you talk of corruption, which is judicial officers, judges, judiciary staff, magistrates corrupt. Now, I can only talk for myself, but the perception out there is that we are corrupt also. We take bribes, which is a very serious indictment, because systems can be put in place to nip this in the bud. If there are people who are moving around corrupting judicial officers, we have systems and structures that can be able to take care of that. We have the ombudsperson's office that takes these complaints and investigates them. And JSC is in charge of enforcing the Judicial Code of Conduct, because it's a very serious crime. It's a criminal offense to take a bribe. So if all these mechanisms are put in place, I believe we can be able to nip in the bud corruption, or make it very expensive if somebody has been found undertaking corruption. They are dealt with, they'll lose their job, because when you go through criminal process, and it's a very painful thing to lose a job, that will deter others from engaging.
Thank you. You've just mentioned about complaints against judges, which prompts me to a question I hadn't anticipated, which is this. How would you address the backlog of complaints of judges, magistrates, and other members of the judiciary pending before the Judicial Service Commission? That would be all from me, Chair.
Yes. Thank you. I think the solution is here with the honorable commissioners. If they have a backlog of cases, we in the courts, we are dealing with we are battling also with the backlog of cases and finding systems of finalizing our backlog. So the honorable commissioners, we will have to sit and see the amount of complaints that are pending, because as I said, complaints clog your mind.
Bear in mind, my lady, that you would be the chair.
Yes. Yes, when I'm the chair, then I'll convene a meeting for us to discuss how to complete these complaints. See whether there is a system that is not working. There's a failure of a system in discussing and finalizing these complaints. Because, it's like a sword of demagogue also hanging on the shoulder of the judge or judicial officer who has a complaint when the matter is not determined. So JSC, I know you work through committees. See whether the committee is not finding enough time to deal with the problems, and give them more time, maybe give them like 2 weeks. They work rapidly, like a service week, to finish all the complaints that are pending, because it is not good to keep complaints pending forever.
Most obliged, Your Ladyship. Thank you, Chair.
Thank you very much, Commissioner, Honorable AG. I will now request Commissioner Gishohi to ask questions.
Thank you, Chair. Good afternoon, Honorable Judge.
Good afternoon, sir.
Yeah, I want us to look at something a bit different now. And before I go to it, something that has been going in my mind right from the beginning. Chief Justice of the Republic of Kenya, he talked a lot about Supreme Court, High Court, magistrates. I'm interested in small claims courts, where most of us, most Kenyans actually meet the judicial system. If you become the Chief Justice, seated in Nairobi, how would you, as a Chief Justice, be able to facilitate the establishment of this small claims court because of our small micro enterprises?
Yes, thank you very much. When I'm CJ, the Small Claims Courts Act is in place. The last time I checked, I think we were in Akorokwam, and we were informed that it is already it's already in place. So what remains now is to operationalize these small claims courts. And I think a survey was done, if I'm not wrong, of where they ought to be opened. Again, budgetary constraints. With my fundraising experience, these are outfits that can comfortably be supported by the county government's CDF monies because they touch the people at the grassroots.
My question, Honorable Judge.
Yes.
Are they functional? Are they operating?
No, I don't think they are.
Yes.
Yes.
So,
but I stand to be corrected. But good. I have not come across one which is operating.
You know that is where the rubber meets the tarmac, because yes. That's where the people are.
Yes.
Not in Nairobi. My next question, before I go to the other issue, you talked about the commercial courts. You talked about 3 years, maybe before a case is resolved. And you are living in a very competitive regional issues in terms of investment. I want to be very clear that as you come in as Chief Justice, the issues dealing with the business, enterprise, investment, what kind of a framework would you be able to institute? The same way you have cases on corruption and all those issues. What kind of framework are you looking for?
In fact, Honorable Commissioner, when the commercial division was established, that was exactly the purpose. That you can't own commerce, you can't own investors. Their cases must be decided within a reasonable time so that businesses can thrive. But within no time, it has been caught by the same backlog that has affected everybody. And earlier on, I think we said we need to look at the capacity of that court, the case management system that is in place, whether it is efficient, you know, really increase the capacity of that court. ICT, you know, these things, technology, working with technology lessens the time tremendously. So look at whether they have completely embraced technology in the commercial court, because it can even be a 24-hour court now that there is technology. When you are sitting at your home, you can work longer hours and be on a schedule until these cases are finished.
We hope that you can be able to address that matter, because it's something that is very urgent.
Yes, the SGT and also the Sonja report all say that a case should not be in court for more than a year. So this is something we have set, a standard that has been set, and we must aim to achieving it.
Now let us come now to the areas that I'm assigned. The Honorable Attorney General have alluded to this matter. As you come in my view, one of the areas that you need to look at very, very carefully is the structure of the commission. To ensure the commission works in a coherent, in a manner that is consensus, and you can be able to tap the talents within the commission. The other area of the judiciary, you might be doing very well. But if the commission is not able to support the judiciary, you will not go very far. I would like to hear from you. Two things that you do, taking into account you have the foundation from 2011 to 2016. You have 2016, 2021. I've been in this commission for 2 years. But I would like to see the chairperson of the commission, what new things that you make the commission move from its comfort zone to ensure that you are able to deliver our services to the Kenyans. Two things.
Oh, my goodness. The structure of the commission. I think the first thing that I'll do is look at the strategic plan of the commission and see how far it has been implemented. I searched for it in the website. I was not able to get it. Maybe it's
not there?
Oh, it's not there. So that's the first thing then to address, the strategic plan. It's there? It's in the...
It's there.
Okay.
I'll proceed.
Okay. Look at what has been implemented and what has really evaluation of the strategic plan. The commission is a constitutional commission. It's one of the 15 commissions of the Constitution. So it's a very strong institution anchored in the Constitution to support the work of the judiciary. So the other thing I'll look at is also the funding for the commission. Is it well funded to be able to undertake its work? Because commissioners have half-time, I think, part-time. They are not full-time. They work with committees. But do we even have directorates, personnel,